we're gonna make this a little more fun than most of your agency classes, okay? Because you're really gonna learn something today that you thought you might have known, but you're gonna learn it at a different level. I'm on the Ethics Grievance Committee, and the #1 document that we look at when there's an ethics complaint is the agency disclosure right off the bat, okay? That is the first document that you can make a mistake on that a panel's gonna look at and say, wait a minute, they crossed the line here. They did not do their agency proper. And will you get fined? Maybe. Will you just have something put in your file? Maybe, but it could get even worse. It could go all the way to the DOS, which is Department of State, and they're pretty crucial about agency disclosure. And I know when you went through your class, it's all about disclosure, right? They really emphasize disclose, disclose, disclose on anything, whether, obviously it's agency right off the bat. Down towards the bottom of the first column there where it says, when do you need to fill out an agency disclosure form? I am going to read this, it's important. Licensees are required by law, this is law, and regulation to disclose to consumers what type of agency relationship that licensee is currently acting under. Generally, a licensee is required to make it clear for which party he is acting. And there's the law, it's stated right there. This requirement applies to all licensees regardless of the type of real property being sold or leased. Okay, you all know this from class. Although 175.7 does not require a licensee to utilize a form to disclose the licensee's agency relationship, licensees should be diligent in their disclosure to consumers exactly what type of agency relationship the licensee is acting under. And that is on the telephone, in an email, anything, okay? So with that, what's that saying is you don't really need the document right there, okay? But it has to verbally be acknowledged who you're representing. And you all understand what a consumer is versus a client, right? Consumer is somebody just calling in on something. They are not actually your client. And you also know that an agency disclosure does not get you paid. Okay? Only a buyer agreement, which is a contract, like your listing contracts, will get you paid. Does that make sense? This is just a disclosure on your relationship. So please practice getting buyer contracts like you do listing contracts. Over on the third column to the right at the top, the issue with first substantive contact is that the DOS provides no definition as to what could constitute first substantive contact. In the past, DOS has used the word or the phrase warm body approach when addressing first substantive contact. The warm body approach is simple as it sounds. Now I jumped down a little. Underneath the law there, it says there are, of course, some exceptions. A warm body approach, the most prevalent, is the open house. You do not need an agency disclosure sign in an open house. You are hosting, if you're not the listing agent, you can say I'm hosting it. You are what? What are you called if you're hosting an open house? What agency are you called? Does anybody know? You're a sub-agent right now, okay? And the only time you'll see sub-agent is on the listing contract. You will not see it in your agency disclosure. That's why everybody gets so messed up with that. You are a sub-agent to the seller because you're helping out the listing agent, even though you don't know the seller. Okay, you're under the same company. I hope you're not doing it for another company. Also, down there it says substantive contact occurs should a buyer express serious interest in discussing the terms of an offer or where a seller's agent is helping a buyer identify suitable property. Another exception to warm body approach is one that is occurring with greater frequency in the modern technology-driven market is emailing, faxing, telephone, and communicating via internet and licensees. This is where you have to still disclose who you represent. So just so you know, when we have an ethics panel or we have a hearing panel, text messages, Facebook, all of that can be put into the panel. Okay, so what you say is very important if you are doing it on social media, that you don't do something that's not unethical or not in the agency law. All of that can be used against you, okay? Now, towards the bottom, I put like a little bracket here on the right-hand side. This was actually a case. So on April 25, 2001, a licensee and the consumer agreed via telephone that the licensee would represent the consumer as a buyer agent. They're a consumer right now. No agency disclosure form was provided in any manner at that time. On May 6, 2001, the licensee and the consumer met for the first time and backdated the agency disclosure form which provided. The administrative law judge determined that although the buyers were not present in Rochester at the time, this is Rochester, New York, Rochester at the time of the contract, the evidence demonstrates that the form could have been faxed to them and they could have faxed back their acknowledgement. The backdating of the form, although intended to show when the first substantive contact was, improperly muddied the issue and was demonstration of incompetency. And it was ruled against the agent. So you cannot backdate documents, period. Okay? Especially agency. With that said, would they probably put something in the file? It depends on the case. If there was an extreme problem in this case, it can be a big fine, okay? So you can't even backdate lead disclosure. That's a federal law, okay? Agency is in New York State right now. Different states are different with agency disclosure. So down the column here where it says when dual agency is discussed, so we're just going to jump to that right now first, the dual agency, because these are just important things I thought came out in this article. When dual agency is discussed with the client will have the option to indicate their consent to dual agency and in advance only. So what this means is this. When you have your agency disclosure, which we're going to bring out, on that disclosure, you have to ask them for advance consent for dual agent or dual designated. Okay, if they don't sign advance consent, guess what? Are you able to do dual agency? No. You could try, and if you don't get caught, you're going to go through with it. But if they call this document up and you didn't have advance consent on your original document, you may not get away with that dual agency. You always have to have that marked. Now, your client has the right to say, no, I don't really want advance consent right now. Don't have them sign it. You have to explain that to them, okay? And that's the same with dual designated for another Keller Williams agent. So with that, then you go to the middle towards the bottom. It says licensee should be aware that dual agency must be discussed with the seller or the buyer at the onset of discussion concerning agency. The law specifically states that the client is agreeing to advanced informed consent. This means the client must be fully informed as to all aspects of dual agency. Clients need to be fully informed as to the fiduciary obligations they will be losing by agreeing to dual agency. And this is on the back of that pamphlet. It shows you different scenarios. Okay, so it's this page here. See, and this you should carry with you if you're not sure. And people make mistakes, okay? So carry this with you. But it shows you how you should be filling it out. And this is actually the top of the form here. And then it goes to the middle. So it gives you a couple samples. We're not going to go through each of these, but I'm going to go to the actual form in about 2 seconds here. So if you come down here, now this is like any document you are having your buyer or seller sign. As an agent, you should know every single thing on those documents. You should know exactly what they mean. If you don't, shame on you. And if you don't, highlight it, give it to your broker or your TL, team leader, or somebody to go over what those things mean. Because why would you be having your sellers and buyers sign something that you don't even understand, right? Is that true? And what really aggravates me as somebody that teaches is when we get to the addendas and people don't even know what a well addenda or septic addenda or an engineer really is saying, okay? You have to learn these documents. This is the most important thing anyone's ever going to purchase or sell is their home, right? So just, I'm not going to lecture you on that. So this is not a contract, and it's right at the top. The only thing that binds you to getting paid is a buyer agreement. That's the only thing. So when somebody's not teaching you how to fill out a buyer agreement, shame on them, because it's very easy to do. And the thing I say in all my consultations is, if I'm going to sell my sellers' houses and list and contract them, if I'm going to buy or drive a buyer around, this is how I do my business, I'm going to do a buyer agreement. Why would I not do a buyer agreement? I have my sellers do it. If you think about it, it's a little discriminatory, isn't it? You have your sellers do it, but you don't have your buyers do it, right? So this will not get you paid. It won't. is just a disclosure. So down here it says sellers. Okay, so what I have here too, I gave you a handout, things to know about agency disclosure. It's right there, and I'll bring it up in a second. But on this disclosure form, this tells you exactly what these mean. Exactly, okay? So you really don't, and even tells you your fiduciary duties in there. So if you don't know this, it's right there. It's all right there, okay? It's very simple. It's not really a difficult form. This thing's not coming down on me. So let's go down a bit here. The seller agent, buyer agent, broker agent, dual agent, and then there's dual agent with designated sales agent, okay? So seller's agent, bottom line is you're representing the seller. Now, it really should say seller/listing agent. I don't know why New York State doesn't do that, but they don't. But a listing just means you have the listing of the seller. You can list a buyer by doing a buyer agreement, right? So that's why they don't put it there. But it's a seller agent, you're representing the seller, the buyer agent, and it has all the fiduciary duties right there. And then you get over to broker's agent. Does anybody really fully understand what broker's agent is? Well, I'm just gonna do one simple thing because it goes a couple different ways. If you have a listing and you're in a different company, say you're ABC Real Estate, okay? And you have a listing contracted with a seller, and you have to leave that real estate company because you're taking your business somewhere else. That listing is actually, depending on the company, because some companies don't let you take your listings, in Keller Williams we do, but that company keeps your listing. You are no longer listed on that property. You have to leave the company stays with the broker, or the listing stays with the broker. Now you go to your new company and you have a buyer that wants to write on your old listing. Can you do that? You cannot. Your fiduciary duties are for life. Does that make sense? So your fiduciary duty is with that listing. You cannot write on that unless, can they agree to dual agency? You're no longer a dual agent. Are you really? You're in a different company. That broker is the person that really has that person as their seller, right? So that's where you get the broker agent from. That's where the broker agent or the broker would write the contract for you because they are a third party. So your new company, that broker can, does that make sense? You can't take your listing and you can't have your fiduciary duties at your new company. You have to have your fiduciary duties. You can't change that. You can't work for the buyer solely. Okay? So
yeah, but if it's no longer your listing, you're not working for the seller.
Your fiduciary duties are forever.
You may know something about that seller. Yeah.
I don't want to say that again. Fiduciary duties are forever. Bottom line. Okay? If you leave that listing, even if it expires, your fiduciary duties were with them. You contracted with them. You signed an agency disclosure. Bottom line.
When you say forever or for life, you mean the life of the contract?
No. Forever.
Well, so what if somebody else bought the home? Not through you.
Mm-hmm.
A year later they sell it. You got a buyer that wants to buy it.
The seller doesn't live there anymore.
That's what I'm saying. So
I said it's person to person. It's not the house. Your fiduciary duties are with that seller, okay? Not the property, with the seller. So if they sold it and another buyer's there and they call you up, you're no longer fiduciary duties, right? It's only with the seller, not the property. Does that make sense? Okay. Yeah, but remember the forever, because that's what agents forget. So now you have dual agent designated. That is your umbrella in New York State, and not all states are the same. New York State, for if you're in the same company, you have dual agent designated, okay? But you have to ask advance consent on your original form for that. Now, I have to say, this really isn't the best designed page, okay? It should be switched up and flip-flopped a little. However, the print your name obviously is you, the licensee, and then your company. What you're gonna mark at a listing is you're gonna mark seller and seller agent. Seller as check relationship below. You can't just mark this, and that's what I find agents doing is they mark just the top one. You gotta hit seller's agent or buyer's agent and buyer agent. You do not touch this whatsoever, dual. That's a whole new form you have to make up if you become a dual agent. Down here is where you're asking for the advanced consent. Now on Authentisign, unfortunately, it doesn't click both of them, right? Have you guys had trouble with that?
Yes.
Yeah, so you have to, when you go into actually doing the signing, you have to move the little X over to it, all right? And you want both of these done at the original signing. Both. Because you don't know if you're gonna sell with another Keller Williams agent. The one thing we are checking out right now, and Andrea's checking with DOS, our compliance director, is if you're a Keller Williams agent in another area like Buffalo or Syracuse, is it dual designated? When I was at a different company, we treated it that way. We are double checking to make sure that that has to happen here too. So if you're a Buffalo Lancaster agent, and now I have had agents that are doing it that way, and I do it that way because I feel New York State only looks at Keller Williams as one, and I believe that is true, but we are double checking it. And the reason I say that is the consumer, the client doesn't understand who's Keller Williams and who isn't. So to me, it should be dual designated no matter what Keller Williams in any part of New York State, but we are trying to find that out, okay? So what you're gonna do is your original form, you're gonna mark the top and that. Then, when your agency relationship changes, if it does, a new form has to be done. Does that make sense? So whenever your relationship changes with your client, so say you start out as a buyer agent, and all of a sudden, you have a listing that they want to see, and you did your advanced consent on both ends. So guess what? You can do this, but you have to, in your acknowledgement up front, whether it's on the phone or email, you have to give permission. And in your consultation to your sellers, you should be talking to them about how you're going to handle this in the consultation before it actually occurs, because then they're not surprised, okay? So when I sit with a seller, I'll say, I'm going to explain dual agency to you because you're going to sign, if you want, the advanced consent. If that comes to permission, and I do have somebody that wants to write on my own buyer, wants to write on your property, I have to ask permission in the front for that. Doesn't mean you have to do it when it happens, I just need permission for it, okay? Advanced consent. So now the buyer says, yes, I want to write on it. I literally have to say to the buyer, do you understand, I represent the seller, this would be dual agency. If you don't want dual agency, I have to refer you out. Okay, if they say, well, we don't mind you writing it, then I have to say to them, well, I have to call the seller and ask permission from them again, okay? Because now it's a dual agency. Now, if it becomes a dual agency, I won't take that original document because my relationship with my buyer has changed and it is also changing with my seller. So I take a whole new form and I write up here, dual agent, and you mark buyer. Okay, and then I have the buyer sign, and I usually put down here, I'll put a check mark, but I'll put buyer next to their name. I take that same form, now you can do two different ones, but I take the same form and write seller over here and have the seller sign it, so that they're on the same form. That's how I do it. There's no rule in there saying which way to do it. But if you want two separate, one for the seller, one for the buyer, you can do it. But I like having both their names on the same form saying dual agent. It's entirely up to you guys. Okay. Any questions so far? Yes,
Just a quick question. So I listed and sold a house last year. It was brother and sister selling the mother's house.
Yep.
I just got a listing done to sell the sister and her husband's house. I almost called you on this because I did another form for both of them.
That's okay.
Even though I've already,
Even though you had the original from the last year,
right.
You still can use that one. Did you guys know that?
Well, that's what I was thinking.
Yep.
I can still use it because she signed it, and then I could just have her husband sign the new one.
Yeah,
But I wasn't
because
sure if
your
I could
agent, your relationship isn't changing with her. You can just add.
Right.
Yep. You can use an original form from a year or 2 years ago. Okay, just so you know. We have a case going on right now where Chuck and I are taking to an arbitration where the agent had an agency disclosure with his client from a year ago on an investment property as a buyer agent. And he was showing this agent houses, or this buyer houses, and in between the houses, the buyer decided to stop at an open house went in the open house, and the agent in that open house said specifically, if you do not use your agent, I can get you a better deal with the seller. Okay? So even though he didn't have a buyer agreement, the buyer actually emailed him and said in an email, we are going to go with the listing agent because she said we can get a better deal if we use her and not you. So guess what? Even though we don't have that buyer agreement, that agency relationship that he had prior, and the fact that he was showing 2 houses and it went into the middle was an open house, and an email that said that from the buyer, it's going to be an arbitration deal. He'll get paid. Okay? So that's an ethics. Not only did this agent cross the line with a relationship with another agent, they took their seller into a very big no-no. They just said, I can get you a better deal with my seller. They had no permission from that seller unless they have it in writing to say that, okay? That is huge. And when you have that put in an email, or you have that on a Facebook page, there was a Facebook post on it too, that you now have put yourself into a really bad circumstance all the way around. So the sheet I gave you, things to know about agency, and I'm not going to read all of this because I just told you some of it here. Seller's representation, buyer's representation, sub-agent. Sub-agent is a little confusing. Sooner or later, New York State's going to just get rid of it, I hope. But like the circumstance I told you where you're hosting an open house for somebody else, believe it or not, you are a sub-agent to the seller. Because you're under the same company, you don't have a relationship yet. Now, the one thing with sub-agency is this, on a listing contract, who knows here you should not be marking that on a listing contract? Does anybody know that? And I don't care if you admit that you don't know it. The reason is an attorney's going to tell you that sub-agency, if you're acting as a sub-agent and you're going to write an offer for somebody, say they're on vacation, another agent's on vacation, and you're writing the offer, you're a sub-agent, okay? You literally are saying things about that property that the seller is actually responsible for, even though you may not know everything, all right? Whatever you say, the seller is responsible for it, because you're a sub-agent. So a listing contract, you will be told from an attorney not to mark that you're going to do 3% or 2% or 4%, whatever your commission is, to a sub-agent. You're saying, I'm not going to pay you if you come in as a sub-agent. That's basically what that means. So on your listing contracts, I highly recommend that if you're going to mark sub-agency on it, that you get a conversation going with an attorney about that. Okay? Because most attorneys are going to tell you do not act as a sub-agent. Okay? So that's why I put that in there, because people get that confused, and it's not on the agency disclosure form, which is really unusual, but that's how they did it. So eventually that'll probably disappear. Then we go into designated agents again, so we don't have to talk now. Teams. Who in here is on a team? Okay, we have one person there, aside the team. So team is a funny thing. New York State is recognizing teams, but they're cracking down on it, because really a team is a sub underneath the broker. Your broker is who is the listing person of those houses. Your broker is the listing of the buyer agreement too, not you. You're just writing your name on there, okay? You are under, your license is under a broker. So a team, the rainmaker, the person ahead of the team, if they list a property, you represent the seller on that team. Bottom line. Because you have access to the files. Does that make sense? You are in their office, you have access to the knowledge of that property. You cannot be a buyer agent designated on a team. You can only be a dual agent if you write on your team's listings. Only. Bottom line, I don't care what they taught you at the board. They taught you it right, okay? There is one instructor that is saying that you can be a dual designated. It's not right, not on a team. On a team, you represent the seller because you're on that team. You're being paid by the rainmaker. You have access to the files. Does that make sense? Okay. I have a lot of instructors that fight us on that, and please don't do it the wrong way, because do you really believe that if it goes to court or DOS, that they're gonna say, oh, you're a buyer agent on Lisa Wasson's team, so you came in on this deal as a buyer agent or a buyer designated, do you really represent the buyer? Because I listed that, I contracted that before he knew that buyer. Or maybe he knew that buyer before, but that buyer signed an agreement and an agency disclosure with him as a buyer agent. So if he's gonna go on my listing, it's a dual agent, okay? So how that's gonna look on that agency disclosure, it's gonna be the team name, or not the team name, I'm sorry, but it would be like Jenna May, and then Jim White on the top, okay, as if it's a dual agency, all right?
So this is where I got nervous over this contract we did. I think you know which one it is.
Mhm.
Anyway, we started out with the Form B. The guy called this one to see the house.
Mhm.
Jenna's listed.
Mm-hmm.
I met him at the house, wanted to rent it off.
Did you
Jenna
disclose
said-
who you represented when you talked to him?
I'm sorry?
Did you disclose who you represented when you talked to him?
Probably
Okay.
as well
all
as
right.
I should.
I love honest people.
No, hey, he wanted to see the house, I
Yeah.
showed it to him, and so Jenna says, okay, so I didn't have him fill out an agency disclosure at that time.
You don't
It was
have
so
to.
fast, you know.
But you don't have to.
So he wants to write an offer. So we put together the offer with the disclosure, and Jenna says, well, yeah, that makes sense because it's really the team name, right?
Mm-hmm.
Which is what you're saying, so I presented. He wanted to make absolutely sure, and his mother, who is an agent in Dutchess County, okay, that I was representing her son.
She doesn't know her agency.
Correct. And I said, and I probably said the wrong thing, and Jenna knew it as well. I said, I absolutely are gonna represent you. It's basically to put the contract together.
You have fiduciary duties. Remember, you do have a fiduciary
Right.
duty. You hold some with that buyer.
So we set it up as dual agency, sent him the contract, of course, his mother's with him, and they're reviewing the contract, and she says, no, absolutely not. You gotta mark this as, dual with designated agents.
And she's incorrect.
Correct. But, you had to talk to this lady to understand, so we changed it.
So if you get audited, you will get fined.
That's what I said to Jenna, I said, I don't feel comfortable with this, I don't think it's right, but
No, you were
we did
right.
what we did, and
Right, you were right. The one thing that you want to make sense of, or really get into the habit of, is when you get a phone call and you're on a team, is you have to say, I just want you to understand I represent, as a team member, the seller. I can still show you the property because they gave you advance consent. The seller, I always get advance consent because of the team part of it. And if they say no to it, then we can't take and show that house to an unrepresented buyer because my seller said no, okay? We could probably maybe show it, but we gotta be very careful what we say because they are saying they don't want dual agency and we represent the seller. So you gotta be careful when you're on a team. So anyhow, with that, you would have said, I represent the seller. If you want to write an offer, that would be dual agency. If you want your own representation, you can either go find your own representation or I can refer you out to somebody. You can refer, and you can get a referral fee from that, guys. It's all okay. Because it's a whole different agent that doesn't know them. So, just so you know, an audit can it can happen anytime. You can be doing an open house, and there could be an auditor that's coming in looking like a buyer, okay? Your seller could be testing you, and I did have this happen at my own team. We were doing an open house. The seller had their sister come in our open house. They wanted to hear what we were saying to people. So always remember, whoever walks through that door, you have no idea who they are. And when you're showing a property, you have no idea if they are not an auditor, okay? So, just keep that in the back of your mind. Now, do they physically do this all the time? No, but every so often they will do it. And right now they're cracking down on social media. They are looking at websites. So they even sent out an email to all the brokers saying, hey, make sure your agents have everything in compliance on their websites, on their Facebook. even on your email signatures. Remember, we've been telling you guys that. We've been sending you out all that information. So, Jim, I'm going to say that she told you the wrong thing, okay?
Oh, I know.
So with the teams, we just started changing this because the only reason I found this out was there was an instructor that was doing a class and they were teaching the team part of it wrong. And I did bring it up to the board and said, hey, this is not right. And I even called our great Mr. Michael Nochi, who knows agency by the back of his hand, and he said I was correct. And then we also called Anthony Gatto for the DOS, and he said, yes, you are correct. And team, it's dual agency, not dual designated, okay? So I was very happy that we've been pushing that because you can get in, agency is the first way to lose your license, just so you know, okay? Okay, so now we are going to do some videos.
Hi Neil, what is the agency disclosure form?
The agency disclosure form is a form that New York State requires real estate brokers to give consumers in connection with residential real estate transactions.
Okay, so what is the definition of residential real estate transactions?
A residential real estate transaction is a 1 to 4 family transaction. It also includes co-ops and condos.
Is the agency disclosure form required in commercial property transactions?
The agency disclosure form is not required in commercial transactions. New York State law requires real estate brokers to give consumers or anyone that's party to a transaction a disclosure form saying how they're acting. Only in connection with residential real estate transactions is the specific agency disclosure form required. Once again, I remind you, though, that a real estate broker is always required to inform the parties how they're acting in connection with the transaction. That would include commercial transactions.
Is the agency disclosure form used for residential rental transactions?
Yes, there are actually two agency disclosure forms. One is used for rental transactions. The other is for purchase and sale transactions.
Okay, so does the form require that we put an address on that form?
No, there's no address required on the form. The form is relationship-based. It's not transactional-based.
Okay, so can you give me an example of what that means, that statement that it's relationship-based?
The agency disclosure form is relationship-based. It's not based on a particular transaction. So, for example, I could be representing a buyer, and I could give that agency disclosure form in the summer. We work together a little bit with the buyer, and then we don't work together for a while. Next summer, the buyer comes back to me, and we're working the same capacity. I do not need to re-deliver the agency disclosure form because I've already said that we're acting in that certain capacity, as opposed to saying that we work on a particular transaction together.
So Neil, if I'm working with somebody and there are time lapses, how much time should I let lapse before I re-disclose?
Well, as we'll talk about later, you can never over-disclose, so there's certainly no harm in, if you worked with someone in the summer and a couple of months go by, to re-deliver the form so they understand what capacity you're acting. But in theory, there is no time frame. As long as they still understand, or you gave the form and they understood that, there really is no time frame.
Does the agency disclosure form create a contract between the real estate broker and the consumer?
No, the agency disclosure form is simply that, a disclosure form. And if you look at it, it clearly says this is not a contract. So no, it does not create any contract between the parties.
Why is the agency disclosure form so important?
Agency is the core concept upon which a real estate broker represents a consumer. It is so important for the real estate broker to let the consumer know how they're acting, what they're going to do, and the responsibilities that are involved with that relationship. The principal engages the agent, and the agent accepts that relationship, that responsibility.
I've heard that many consumers complain that they're unsure how a real estate broker is working on their behalf. Is that correct?
Yeah, I think nationwide one of the biggest complaints that consumers have about the real estate broker and the relationship is that they don't fully understand how the real estate broker is acting on that consumer's behalf.
So that's why the disclosure form is so important.
Exactly. As we said, it's the core concept upon which the relationship is based, and therefore you obviously need that consumer to understand what the relationship is.
So the agency disclosure form is not only given to the party that the real estate broker is representing?
That is correct. In fact, that is a very big misconception. I like to think of the agency disclosure form as a big business card. And the purpose is to give all the parties an opportunity to understand how the broker is acting in connection with that transaction. So for example, if I am the broker and I am representing a seller and I am meeting with a buyer, I will give them the agency disclosure form that says I am representing the seller. I am not giving them the agency disclosure form that I entered into with the seller. I'm giving them a new form that says I am representing the seller in connection with this transaction.
Okay, so to be clear, the form that's given to that prospective purchaser, is that the same as the form given to the seller?
No, actually, if I'm engaging with the seller, I give the seller a form that says I represent you, the seller. Then, once I'm representing the seller, when I come across a buyer, I'm going to give them a new form that says I represent the seller in connection with this transaction.
Okay, well, that makes sense.
Something here that I do as a practice that you might want to do is on that first page of the agency disclosure, at the very bottom, I put in authenticine or handwrite initialing it. I make them initial that first page. I taught Michelle that because that means they have read it and they've seen it. And anytime anyone signs a contract or a document with you, you immediately have to give them a copy. So the one thing that comes across our ethics all the time is the consumer says we never got our copy. If you don't get your copy, if the consumer doesn't have a copy, that is a huge ethics problem. So whenever they sign an agency disclosure or anything with you, you should always give them copies, okay? It used to be in the old days, we had that, you know, what was it called?
Carbon copy?
Carbon copy, yeah. Can't even remember the name. So I actually make them sign that first page, or initial it at least. And I circle buyer at the top just like he did.
Neil, before we talk about agency relationships, can you explain how an agency relationship is created?
An agency relationship is created like a contract. It is a meeting of the minds between the buyer, for example, and the agent. There has to be an understanding that the buyer wants to engage the agent, and the agent wants to be engaged by that buyer to represent them in connection with the transaction.
That brings to mind a question I often hear. Does compensation create agency?
Compensation does not create an agency relationship. So, for example, it's not uncommon for a buyer's agent to be representing the buyer, yet be paid by the seller. So once again, by paying someone doesn't create an agency relationship.
Okay. So before we talk about agents, I want to ask you about the terms client and customer, which I often hear used interchangeably. What is the difference between the two?
The terms client and customer are actually colloquial. And while they may be defined in various parts of the law, I am very much in favor of using the specific reference to the party I'm representing. So if I'm representing a seller, then I should say I represent the seller. If you're representing the buyer, you should talk about representing the buyer. Again, because these terms have been used over time, but they are used differently depending on who you're talking to. Mm-hmm. I would very much prefer to see a real estate agent say, I represent the seller, for example.
I see. It's a lot clearer that way.
Absolutely.
So let's discuss agency. What are the obligations that a real estate broker owes to the party that they represent?
A broker has very specific obligations to the party that it's representing, and we use the acronym OLD CAR. The O stands for obedience. The L stands for undivided loyalty. The D stands for full disclosure. The C, confidentiality. A, duty to account. And R, reasonable care. And those are the most important things, the legal obligations that the broker has to the consumer that they're representing. Again, OLD CAR is the acronym.
So in addition to these duties that a broker owes to the party they represent, do they owe anything to the other parties in the transaction?
Yes, a broker owes, in addition to the obligations that they owe to the party they're representing, they owe obligations to the other party. A seller's broker has an obligation to a buyer to exercise reasonable skill and care in the performance of the agent's duties, deal honestly, fairly, and in good faith, and disclose all facts known to the agent materially affecting the value or desirability of the property, except as otherwise provided in law.
Okay, so if I'm representing the buyer, then I owe duties to the seller.
Correct. So the same concept. You have an obligation to exercise reasonable skill and care. You have an obligation to be honest and truthful. And then if you are representing the buyer, you have an obligation to the seller to let them know if you know something, some material fact, which would prevent the buyer from completing the transaction.
If your buyer has a term on their mortgage, okay, that if they don't fulfill that term, that condition, and what's your obligation there to the seller? Do you tell them that right up front? It's a fine line with which is privacy law too, okay? So nowadays, it used to be that the mortgage commitment was totally given to the buyer agent when they got mortgage commitment. You got 10, 15 pages. Now they don't do that anymore. They just say you have mortgage commitment. These are the conditions that you have left to do. Now, if you know as an agent that something is risky on that buyer, you owe to that seller to know. They need to know that, because you're holding a deal up. And what I mean by that is, say they have to pay off their car and they don't pay the car off, and you held them up for 2 months on a deal, and then I could held up for 3 months, and you haven't disclosed what's going on. That is what they're talking about. You have to say to the seller, or to the agent, I should say, my buyer has some things that they have conditions that is probably a 90% chance those conditions will be taken care of. There is a 10% chance there might not be. Now, do you have to do that right away? Maybe not. You got to get through the mortgage process on that. Yes.
To touch on that, a buyer's agent has to tell the seller their buyer needs grants to buy the property also.
Yep.
Okay, that's what I thought.
You got to put that right on the contract.
That has to be in the offer.
It's got to be right on the purchase contract, contingent upon grants being accepted, or a what do they call it? An award letter.
Okay.
For the grant.
Okay.
Yes.
What section was that going? Just
Other. Yep. Or you can put it on an addenda. Yes.
Okay, and what would happen if, because I kind of came across that situation where I was listening and the buyer came in, and then a week before closing, either I didn't look on the contract or the buyer's agent didn't tell me. They're like, oh, we're waiting for our grant now. And I'm like, well,
if it wasn't on the contract, then the buyer agent was wrong.
That's totally
That's
wrong
what this is talking about, disclosing a fact.
Okay, yeah.
That fact is they need a grant to close
That's
on
what I
the
thought.
property.
The point is, yeah, you have to.
And the reason
Under
is
any
this, in this
circumstance,
market especially, Colin, if you got fighting and competing offers and one doesn't have a grant, your selling agent is going to want to take the one without the grant because it's less risk for the seller.
Exactly.
So if you're not disclosing that as another agent, you just put that seller at risk.
Yeah,
Yes.
definitely,
Yep.
definitely. Okay, that's what I thought.
Okay, anybody else?
Can I ask, so one of the people I'm mentoring had a listing, they accepted an offer, and after they came to terms on it, the buyer agent came back and said, oh, by the way, they want to use a grant.
They want to do what?
They wanted to use a grant,
They need to do an addenda to that.
which I told them that.
Yes.
They did an addenda,
But that's an after the fact kind of thing and it's wrong.
So that's completely wrong.
Yeah. And it could be a miscommunication between the bank and also the agent. But yes, and we've had them this year, which is really sort of upsetting, is they're coming in as a cash offer and all of a sudden they want to come back and do a mortgage. Well, guess what? That's a counter. And if there's a backup offer, that backup offer is good now. So just remember, when you write a deal, what you're putting on that contract is what that seller agreed to or that buyer agreed to. If you're going to change something, you need to do an addenda for it. And this happened to an agent in our office. A day later, they came back and said, oh, we're getting a mortgage. Oh, no. The attorney approved it as a cash deal. So that means you can go and try and get a mortgage, but if you don't get a mortgage, you're still paying cash. And if you can't pay cash, you're getting sued. That's basically what that means, okay? Because you came in on a false pretense that you were doing a cash deal.
Neil, what is dual agency?
Dual agency is a situation where a real estate broker represents both parties to the transaction at the same time. So for example, we have a big firm, ABC Company, and ABC is representing both the purchaser and the seller. That is dual agency.
Is it legal in New York?
Dual agency is perfectly legal in New York, provided that it is disclosed to the parties, and if it is created, that the broker then confirms with the parties and lets them know that the dual agency was created.
Okay, why is it important?
In order to understand why dual agency is important, you need to understand a couple of concepts. The first concept is there is only one broker concept. And what that means is that, for example, let's talk about ABC Company. ABC brokerage company may have 500 agents, but even though an agent may bring in a seller, there is only one broker, and that's ABC Company. So that's the first important concept. The second concept is the concept that it is not unusual for ABC Company to represent both buyers and sellers at the same time, for example. So ABC Company will represent buyers, it will be representing sellers, landlords, and tenants, and so on. So again, it's not that uncommon for a dual agency relationship to be created. The third concept is the idea that ABC Company may have multiple offices. And so, for example, ABC Company may bring in a seller, a listing of a seller's property, and there may be an agent in another office of ABC Company that is representing the buyer. So, as you can see, dual agency is fairly easy to create in New York by virtue of the way that business is conducted in New York by real estate brokers.
What is advanced informed consent to dual agency?
Advanced informed consent to dual agency is a very important concept because it gives the real estate broker flexibility. It gives the broker the ability to explain to the consumer what dual agency is, and the consumer then gives the broker the ability to potentially create that dual agency down the road.
What does informed consent mean?
Informed consent is where the broker explains the dual agency to the consumer, and the consumer therefore understands what they're consenting to. It's a concept where the broker adequately explains what the dual agency is.
Should a real estate broker always have a consumer give advanced informed consent to dual agency?
The broker should always obtain advanced informed consent to dual agency. Given our environment, and we'll discuss this in other videos, it is extremely important that the broker has the flexibility to potentially create a dual agency relationship. Without that, the brokers will be very constrained in what they can do.
Does the real estate broker have to inform the parties when their dual agency is actually created?
Yes, New York State requires that once the dual agency is in fact created, that the broker goes back to the consumers and lets them know, lets the parties know that yes, the dual agency was created.
At the time of disclosure, could the parties still decide that they are not comfortable with dual agency?
Yes, they still have the ability to say, you know what, I'm not comfortable with this. Now, I personally think that will be unlikely in the fact that both parties have already been informed, so they've already given their consent, and more importantly, the transaction is being completed, so, or the parties have agreed. So I think it would be unusual for them to decide not to proceed at that time.
I see. And what is dual agency with designated agents?
Dual agency with designated agents is simply a situation where the broker decides to appoint one agent that works at the brokerage to represent one of the parties, and they will appoint another agent to represent another party. So, for example, ABC brokerage company can appoint one agent to represent a buyer, and they can appoint another agent to represent the seller.
Neil, what does it mean that REBNY is a true buyer representation environment?
In order to understand what the true buyer representation environment is, we first need to talk about something called subagency. And subagency is simply a situation where for example, a seller engages a broker, and then that broker cooperates with other brokers, all the brokers are acting as sub-agents of the seller. So we have a seller engaging a broker, and then that broker, there's an agency relationship, and then the broker engages other brokers, and everyone is acting as a sub-agent of the seller.
And do these sub-agents work with buyers?
Well, that's what's interesting. In a sub-agency environment, even though they're representing the seller, they are frequently working with buyers. So a sub-agent may be taking a buyer around to see multiple properties when they're in fact really the agent of, or the broker of, the seller.
So that explains why so many consumers are confused about who's representing them.
Exactly. So that's why when the consumer says, I don't fully understand how I'm being represented, you can understand that. The broker is representing the seller, yet showing the buyer all these properties, and they don't really understand who's representing them, acting on their behalf.
So now with that in mind, what does it mean that REBNY is a true buyer representation environment?
REBNY is a true buyer representation environment. What that means is that unlike many other organizations, when a REBNY broker takes a listing from the seller, that REBNY broker represents the seller, and all other brokers that cooperate with the seller's broker are representing the buyers. So there's only one broker that represents the seller. All other brokers are representing the buyer.
Should real estate brokers explain this to the buyers they're representing?
Yes, I think that REBNY members should be very proud that they work in this true buyer representation environment, and that except in the cases where they're representing the seller, they are representing the buyer. I think it's a very important concept.
I should say in Rochester area that actually did just represent, the broker only represented buyers. The hard part with that is it didn't last. And why doesn't it last? What gets you the money? What gets you the
Listings.
Listings are why the buyers call. And if a brokerage only represents buyers, they've got to be marketing themselves at a high level for that. And it can put you out of business if you don't do it right. Okay, so they don't push it in this area. It is in New York State. We've had them where they solely represent just the broker. The broker owner represents buyers only. And there was one that was here and it did not last. And that's because, one, they didn't market themselves the right way and put enough money towards it to be able to draw the buyers to work with them exclusively to go find them listings, okay? So that sort of explains that sub-agency. And the sub-agency is a risk in a lot of ways because of the fact that the representation, everybody's working really for the seller in that with the sub-agency, all right?
When are you required to give the agency disclosure form?
The law requires the broker to give the agency disclosure form in two specific instances. One is where prior to the broker entering into an exclusive representation agreement with the consumer. The other is when they have first substantive contact with the consumer. So there's two situations. One, prior to an exclusive representation agreement. Two, prior to substantive contact, first substantive contact with the consumer.
Can you give an example of what an exclusive representation agreement is?
A listing agreement is an example of an exclusive representation agreement. A listing agreement between the seller and the broker, where the seller engages the broker to exclusively represent them in selling a property.
Okay, and then what does first substantive contact mean?
First substantive contact reminds me of a famous Supreme Court case, and the Supreme Court case addressed the issue of pornography. And the justices said that they couldn't define pornography, but they knew it when they'd see it. And so I would tell you that first substantive contact is probably going to be the same type of thing. You'll know it when you see it.
Okay. Can you ever give the form too many times or over-disclose?
You can never over-disclose. The form is simply a disclosure form, and you can never explain how you're representing too many times.
Okay. Does the consumer have to sign the agency disclosure form? What happens if they decide not to sign it?
The law says that you have to give the agency disclosure form. The law doesn't make the consumer sign the form. So if the consumer, once you deliver it, if the consumer decides not to sign it, the broker needs to prepare something called an affirmation.
Does this affirmation have to be witnessed?
The affirmation has to be witnessed. There's a misconception that it has to be notarized. It only has to be witnessed. And there are 2 witnesses, and all the witnesses are doing is witnessing the broker signing the form. They didn't need to witness the broker trying to give the form.
Can the agency disclosure form be delivered electronically?
It can be. The agency disclosure form can be delivered in any form, so it could be delivered by fax, PDF, and so on. And the Department of State has confirmed that, in fact, this form can be delivered electronically.
Real estate brokers are often having lengthy conversations with parties, especially foreign parties, before actually meeting. Should a broker disclose the agency disclosure form prior to meeting?
Sure. And again, I feel that you can never over-disclose. Once you start conversing, whatever the case may be, I think you should give it. And then we're going to talk a little bit later about the importance of the agency disclosure form as a marketing tool.
What should a broker do with the agency disclosure form once it's been signed?
The broker is required to hold on to the agency disclosure form for 3 years. I recommend that it's scanned in because they don't need to keep the original, but then they have a copy, and I would suggest that they just hold on to that copy. So 3 years.
Okay. So let's discuss open houses. Are you required to give an agency disclosure form to everyone who comes to an open house? Because sometimes it's just too busy and that's impossible.
The Department of State has specifically offered an opinion that you do not need to give an agency disclosure form to everyone that walks through the open house. You simply need to give the agency disclosure form to buyers that you enter into first substantive contact with.
Okay, and then what should a broker do if a consumer refuses to register or sign the agency disclosure form?
I personally would suggest not showing them or walking them around if they refuse to register. I would take that position.
Is a broker required to give an agency disclosure form to a consumer who's accompanied by their own broker?
No. The Department of State has specifically said that it is not first substantive contact if a broker comes in contact with or meets with a consumer that is accompanied by their own broker.
What happens if a co-broker sends their client to an appointment but is not present?
Right, so we talked about the word accompanied, and I would take the position that even if the consumer is represented by a broker, if that broker is not accompanying the consumer, that the real estate broker should give the agency disclosure form to that consumer then.
Can an unlicensed assistant distribute the agency disclosure form on behalf of a broker?
An unlicensed assistant presumably could deliver the agency disclosure form, but I would certainly hesitate for them to do anything but deliver the form. So could they send an email on behalf of my broker attached as an agency disclosure form? Sure, they could certainly do that, but they cannot answer any questions concerning that agency disclosure form.
I have one final question about the delivery of the agency disclosure form. Can a buyer's broker ask the seller's broker for the agency disclosure form that the seller signed?
Sure. There's nothing wrong with a broker asking another broker to see the agency disclosure form that the broker entered into with their consumer. However, there is no obligation for a real estate broker to deliver their agency disclosure form to another broker.
And that's true vice versa as well?
Correct. There is no obligation for the broker to deliver the agency disclosure form that they've entered into with their consumer to another broker.
Bottom line is you really need to disclose, okay? That's on anything, and you'll protect yourself that way. All right?